Hi everyone, I am Erin Cobb of Kriezelman, Burtons and Associates here again to talk to you about some immigration terms and abbreviations. Today we're going to talk about the 10-year bar. What is it, when does it apply, and what do you do about it? So who does the bar apply to? The most simple way to think about it is that it applies to someone who is here without status for more than 1 year. However, that is really oversimplifying things. Really, it applies to someone who is here and has accrued unlawful presence for more than 1 year. Now, unlawful presence is a special word with a special meaning. Congress and the Immigration Service have set out some special situations where someone might be here without any status but still not accrue unlawful presence. So let's talk about some of the most common situations. If you have DACA, you are not accruing unlawful presence. If you have an asylum application pending, except if you've worked without permission, you are not accruing unlawful presence. If you're under 18, no matter what your status is, you are not accruing unlawful presence. Of course, if you're in valid visa status, you are not accruing unlawful presence. If you filed an application to extend or to change your visa status, for example, from a visitor to a student, and are still waiting for a decision, you are not accruing unlawful presence. If your visa is one of those that is valid for duration of status, or DS, like some F, J, or M visas, you are not accruing unlawful status. These are the most common situations. There are some more. But chances are, if you're here without status and none of these situations apply to you, you are accruing unlawful presence. If you have more than 1 year of it, then if you depart the country, you will have to wait outside for 10 years before you can even apply to come back in. Except there is a waiver available of that 10-year bar. If you can show that your permanent resident or U.S. citizen spouse or parent would suffer extreme hardship if you are not permitted to return to the United States, you can have that 10-year bar waived and return immediately. This waiver is known by a couple of names. Most commonly, we call it an unlawful presence waiver or an I-601 waiver, which is the form that's used for it. Now, another thing is called a provisional waiver. This one is great because you can apply for it before you ever leave the country. The standard is the same, but it takes out some of the risk and some of the length of time that you would be waiting outside. Please know that there are more bars as well. This is simply one of the most common. So if you're thinking about departing the country to apply for your immigrant visa, please make sure you talk to an immigration attorney first to have everything in place before you go. As you can tell, this is all quite complicated, and the effects can be both life-changing and long-lasting, so you want to make sure you're prepared. Thank you for watching. Please stay tuned to check out more of our videos on information and explanations on immigration law.